The last matter to come before us this morning is in re TA, JA, TB, JB, and KB. As you know, each party will have 15 minutes to present an argument. The appellant proceeds first and may reserve up to 5 minutes for rebuttal. If you wish to reserve any time, please let me know. I'm keeping time for you. We've read the briefs and we are ready when you are.
Your Honor, Robert Cabrera on behalf of appellant Kurt Burgess. The matter before the court this morning is on appellant's objection to the magistrate's decision that adopted a case plan that placed the legal custody of the minor child, KA, into the possession or legal custody of maternal grandparents. Your Honor, the appellant would argue that even though legal custody is not as severe as permanent custody, it is intended to be permanent, which would mean that they would have legal custody of the children, or a child until the child turns 18. And of course, the legal custody vests with the party. In fact, the statute says it's defined as legal status, which vests the custodian with physical care and control of the child, and determines where and whom the child shall live with, the right and duty to protect, train, discipline, provide the child food, shelter, education, medical care, all subject to residual parental rights and responsibilities. But in essence, Your Honor, those rights are what a parent would normally be obligated to fulfill as their parental duties. The residual parental rights, in fact, offer very little to the parent. In fact, the statute likewise indicates that the residual rights are the privilege of reasonable visitation, consent to adoption, to determine the child's religious affiliation, and the responsibility for support. So, Your Honor, my client would argue that it is a serious matter before this court, and that the magistrate's decision, and likewise the court's adoption of the magistrate's decision regarding the case plan, was an abuse of discretion and not supported by the evidence. Likewise, the statute is specific in regards to the goals of the case plan. The goals should be consistent with the best interests of the minor child, and should take into consideration special needs. And secondly, it should be written in such a way with due speed to eliminate this out-of-home placement. So the argument before this court this morning is this case plan is not specific to the child's best interest. The child's best interest would be to reunite with the biological parents.
If I may, then why didn't he file an objection to the magistrate's decision?
Your Honor, I think and I wasn't trial counsel, I think the trial counsel looked at the case plan, and it was the dispositional alternative is what was the ultimate. Assuming for argument's sake that he concurred with the disposition of the magistrate, it is the dispositional order by the magistrate that he brings forward before this court.
But it sounded like in the record that counsel affirmatively indicated that what he was seeking on behalf of the father was visitation, and that the court granted that, and therefore the battle was over.
Well, I believe, Your Honor, and of course, the trial counsel had one objective, and the appellate counsel has a different objective. The parties come in and they discuss the matter with us, and then we proceed accordingly.
Sure.
The visitation, the idea, the dispositional alternatives to the magistrate, however, could have also been legal custody to the father. In this particular case, the father had filed a motion for legal custody. He had litigated that. He had intended and sought legal custody. So
this is only for the baby, right? This is
correct.
For the other 3 children.
Yes, this was for KA. And of course, Your Honor, I'm limited to the docket. I'm restricted by the boundaries of the docket and by the evidence that was presented to the court. So my argument this morning, of course, pertains to KA. And likewise, the agency has to incorporate all of them on all case numbers on one case plan. I think that's what's a little bit, because the other 3 children are also on the case plan that objecting to. So in some ways, my client would concur with mother's objection to the case plan. However, his specific objection is that it didn't provide for the best interests of the child, and it's not, the case plan is not tailored to meet that objective. In fact, in addressing the specifics of the case plan, I would argue to this court that it is more of a maintenance. It maintains, it focuses on father's substance abuse and asks for reporting and asks for counseling and cooperation with the agency, cooperate with LCC caseworkers, schedule appointments, if additional services are recommended, provide drug screens as requested. Likewise, assist in the development of visitation and plan. Those are in form of maintenance. Nowhere inside this case plan does it say, if and when you complete this program, if and when you conclude, if and when you present this to the court, that will terminate this plan, or we will always consider it and then terminate this plan. Now, of course, the agency is going to argue that that's underwritten, or the underlying objectives in the case plan is review and then to modify. But again, if a case plan is specific and tailored, then that should be there as well, and it is not.
Well, so is your argument then twofold, that one, it was not tailored enough, but also that your client met the objectives of the case plan, or do you concede that he fell short?
Your Honor, I would argue that he has met that. I would argue that he met that in the evidence that was presented to the magistrate at the dispositional hearing. He had pretty much complied with everything the agency said. In fact, that would be an underlying critique of the case plan, is that it doesn't really specifically address anything differently than it did prior to the dispositional hearing. Even the visitation schedule, he's required to continue visiting with the child. This case plan requires that he visits with the child for 2 hours, minimum of twice weekly for 2 hours. Nowhere near does it say where visitation will be expanded. If the purpose behind this case plan is to evaluate father's progress on the case plan, progress with reunifying the child with the biological father, nowhere in here does that indicate that in any way. There is no threshold. There's no hurdle for father to overcome. It is more of a maintenance type. Keep doing this, keep doing this, keep doing this, and we'll see what happens. I don't believe that's what the statute calls for. I don't see how that is specific, particularly with due process, how that is specific with due speed to eliminate the out-of-home placement. That could go on until the child turns 18, and I think that's the problem, essentially, with this. In fact, there's a group sheet that includes all the fathers, or at least that's how it's written. And likewise, it's the same thing. It just requires all parents. Give caseworkers name and addresses of adult relatives. Discuss with caseworkers the pros and cons of any relatives. Work with caseworker on permanency plan. Follow visitation schedule. Providing child with all needs. Support the caregiver in caretaking of the children. Attend children's appointments. Attends and invites supportive friends. Nowhere in there does that indicate that. Your Honor, I take the statute as it's written, and I take what the legislative intent must have been or should have been. And if they are requiring due speed, and if the objective, the end game is to eliminate the out-of-home placement, then each and every item or request ought to be specifically tailored to somehow accomplish that. And I don't believe in a general sense. I think it ought to be in a specific sense. If it's substance abuse, which is a problem here, and most of the requirements ask the father to address those things, how is it that, or when is it that that is no longer a problem? How does it end where he can then take the child back? This is saying, in some ways, that a person in recovery can never properly parent their child. And I believe that is not the intent of the statute. Intentionally.
Let me just interrupt to say that if you wish to reserve 5 minutes, you're in that.
All right. With that, I will rest.
Good morning. May it please the court, my name is Emily Kirsch and I represent Lorain County Children's Services. Both mother and father appealed the magistrate's decision which granted legal custody of the 5 minor children to various relatives. I'm going to address father's assignment of error first, however, parts of mother's assignment of error comes in later in the analysis, so I'll address that when I reach that part of the argument. As an initial matter, I'd like to point out that father failed to object to the magistrate's decision and he has not argued plain error on appeal. Juvenile Rule 40D3B4 is very clear that a party waives all claims on appeal except for a plain error claim if the party does not object to the trial court's findings of fact and conclusions of law. In this case, the record is very clear that father agreed with the proceedings throughout this entire case. The adjudication happened on September 24th, 2013. The entry is very clear that father stipulated to the adjudication. Furthermore, the initial disposition, which was protective supervision to Children's Services, occurred on or about October 15th, 2013. Father agreed to that disposition and his signature is on the entry. Furthermore, in that entry, it adopted the case plan that had been filed in this case and the case plan that appellant is now arguing about. He agreed to that case plan, though, on that date. Subsequently, there was an FDO, and on or about April 28th, 2000, further dispositional order, sorry, Your Honor. And on or about April 28th, 2014, father agreed to place the children in the temporary custody of relatives. Again, he signed the entry. Father never objected to any of those decisions. Then there's the trial court's decision that granted legal custody of the children to relatives, and that's what Mr. Cabrera is arguing today. In that case, father was very clear that he was not seeking custody of the children. Instead, he simply wanted visitation, which is exactly what the trial court granted. At the objection hearing that occurred on or about May 7th, 2015, father's attorney stated, and I'm going to quote this, "I did not object to this matter because the magistrate decision did grant my client what he was asking for." Father, therefore, failed to object to the magistrate's decision. He does not argue plain error on appeal, and this court has held that it will not construct a plain error argument on behalf of an appellant that does not raise it in his brief.
At what point did father file a motion for legal custody?
He filed a motion for legal custody as to 6KA, who is not a child subject to this appeal. That was a separate proceeding. Bless you, Your Honor. That was a whole separate proceeding.
Okay.
That case is not on an appeal in this matter. Which brings me to my next point, is that the trial court did not abuse its discretion by adopting Children's Services' amended case plan, placing 6KA in relative care. Father's assignment of error does not involve the children who are subject to this appeal. The children as to father that are subject to this appeal is 3TB, 4JB, and 5KB. His assignment of error addresses 6KA. During the 3-day contested hearing, mother gave birth to her 6th child, which was 6KA. Shortly after mother gave birth, Children's Services sought and obtained emergency temporary custody of 6KA. After Children's Services obtained emergency temporary custody, a case was filed with the court, and that was a whole separate proceeding where the child had to be adjudicated and a disposition had to occur as to that child.
In a separate case.
In a whole separate case, Your Honor, yes. However, upon Children's Services obtaining custody of a child, they are statutorily obligated to file a case plan reflecting such. 2151-412A1 provides that Children's Service Agency shall prepare and maintain a case plan for any child who the agency has custody of. Therefore, upon the agency obtaining custody of 6KA, a new case plan had to be formed, adding the child to the case plan. Children's Services then had to file the case plan, and that is what was filed in this case. However, the amendment sheet to the case plan is very clear that the only thing that is amended on the case plan is adding that the 6th child was placed in the temporary custody of Children's Services. The case plan goals as to father and the case plan goals as to the children, in this case, 3JB, 4JB, and 5KB, did not change. Father's assignment of error, therefore, does not address these children. And he has failed to explain how this amended case plan as to 6KA, a child not subject to this appeal, deprives him of due process with respect to these 3 children. Additionally, Children's Services proved by a preponderance of the evidence that it was in the best interest of the children to be placed in the legal custody of relatives. This also addresses mother's assignment of error. In this case, it was very clear that mother and father failed to make progress on their case plan. This court has held that successful completion of the case plan is not dispositive on the issue of reunification. Instead, it is simply a means to a goal, not the goal itself. The goal itself is that the parents need to demonstrate that they have remedied the issues that caused the children to be placed outside of the home. In this case, as to mother, there were 4 issues that led to the children being placed outside the home. The first one was concern about drug abuse. When mother gave birth to her 5th child, 5KB, mother and the child tested positive for cocaine. After that, there were still 2 other incidents of chemical dependency that showed an indication of crisis. In January 2014, after Children's Services had had protective supervision and was working with the family, mother attempted suicide by drinking alcohol and an unknown amount of pills. The record was unclear whether or not the children were actually in the home when this occurred. Additionally, subsequent to that, there was, mother did a drug screen which was positive for an opiate, and she could not produce a prescription for that. The testimony established that mother did an assessment and she was recommended for intensive outpatient treatment. Mother, however, never followed those assessment recommendations. Instead, she got subsequent assessments. There were concerns about those subsequent assessments because those are based largely on self-reporting. So if someone doesn't report they have an issue, there's going to be no recommendations. There are also concerns about mother's ability to meet the basic needs of the children.
When mother gave birth to KA,
Yes.
the most recent child, were there drugs in KA's system?
There was no report that the child tested positive for any drugs.
So it was the 5th child?
It was the 5th child,
Okay.
the child that is subject to this appeal.
Okay.
As to the basic needs, there were concerns that mother could not keep the home in a clean and sanitary condition. When Children's Services first obtained the case, the home was cluttered and was not in good condition. Subsequent to that, Children's Services was granted protective supervision. However, mother was not cooperative with allowing the caseworkers into the home. Therefore, Children's Services was not able to view the home. In January 2014, service providers were able to gain access to the home, and they described the home as deplorable. The guardian ad litem testified about his view of the home, and I'm going to quote this. "I've been to cluttered houses before. I've been to dirty houses before. But I had never been to one that was so filthy that I wouldn't sit on any of the furniture or want to touch anything." Additionally, there were concerns that mother had failed to recognize as to how her home got into this condition. The guardian ad litem further testified, and I quote, "I have no indication that mother can sustain it if she doesn't know what caused it in the first place." There were also concerns about mother's parenting. There was concern that mother was not providing adequate supervision and that she had a difficult time managing the stress that was associated with parenting. The testimony established that mother did engage in some parenting classes. However, again, she refused to recognize that her parenting was an issue. The guardian ad litem testified that he hadn't seen anything that had changed with respect to her parenting style. The last concern had to deal with mother's mental health. The testimony established that at the time of the adjudication, mother had unstable mental health, that she was hostile and cooperative. Throughout this case, there was the incident in January 2014 where she attempted suicide, and she had been making suicidal threats for 3 days prior to that. Additionally, the testimony established that mother engaged in counseling but had failed to demonstrate any of the behavioral changes. As to father, although there was the concern about the drug and alcohol use, I think the bigger concern on the case plan had to deal with father's inability to meet the basic needs of the children. Appellant is arguing that the case plan wasn't tailored to father. However, father had to at least be able to provide the basic needs of the children, and he was never able to demonstrate that he could do that. And in fact,
He was working, wasn't he?
Yes, Your Honor, he was working, however.
And contributing to something to the children.
Your Honor, the testimony was a little unclear about that. I believe the testimony was that he was not paying child support and not contributing, as Ms. Furman, the caseworker, testified, and I quote, "If he's not capable of providing financial support to the caregivers, I would question how he would financially support the children in the home." That was a direct quote that Ms. Furman had testified to with respect to father providing for the children. Additionally, there were concerns about father's ability to maintain a home. The testimony established that he was homeless for a majority of this case. Furthermore, the testimony established that he had recently started renting a room in a home just prior to the contested hearing. The person from whom he was renting the home, Ms. Young, testified. However, there were several discrepancies between Ms. Young's testimony and father's testimony, which also sort of called into question the validity of this housing. For example, father testified, I don't know if it was father that testified, but the testimony did establish that father had been homeless and just recently obtained the house. However, Ms. Young testified that he had been living there for 2 or 3 years. Furthermore, father testified that there was no lease, his name was not on the lease, and Ms. Young testified that his name was on the lease. Furthermore, father admitted that he did not have the room to house the children. Based on this, it was clear that father had not demonstrated that he would be able to meet the basic needs of the children. In addition,
Was there any testimony that anyone at the agency had assisted him or had, made referrals that would assist him in gaining housing that would have been appropriate for the children?
I don't believe that there was any testimony as to that, because I believe the testimony established that father had been very clear that he did not want custody of the children, that he was simply seeking visitation of the children. I believe that the guardian ad litem testified as to that. The guardian ad litem testified that father had never indicated an ability to, or interest to have the children full time. So I believe that would be the reason why there was nothing done with respect to that. In addition to Children's Services proving that the parents failed to make progress on the case plan, Children's Services also proved that it was in the best interest of the children to be placed in the legal custody of relatives. This court has held that although a parent's case plan compliance may be relevant to the trial court's determination of a child's best interest, it is certainly not dispositive. Instead, the court must look at the factors set forth in 2151-414D. The first factor is the interaction, interrelationships of the child with the parent, siblings, or any other person that is important in the child's life. As to mother, the testimony established that the children had a difficult time seeing mother as an authority figure, and they had a difficult time following her structure and rules. As to father, the testimony was that his interactions were positive with the children. The concern was that most of his interactions were with mother, and father and mother were still together. So the concern was that while father was with the children, mother was also there who was not having positive interactions. The testimony established that the children had positive interactions with their caregivers. As to the oldest child, he was with his father, and their bond was described as amazing. As to 2JA, the testimony established that he was doing great with the paternal grandparents. As to 3JB and 4JB, the testimony was that they had spent a lot of time with the maternal grandparents prior to this case. And as to 5KB, the testimony was that she was obviously bonded to the caregivers. The guardian ad litem summed up these placements by stating, and I quote, "The children have wonderful placements and it would be cruel to even consider moving them." The next factor is the wishes of the children. This factor weighed in favor of granting legal custody. The 2 older children were happy in their placements. As to the younger 3 children, they were too young to express their wishes, and therefore the guardian ad litem was recommending that legal custody be granted to the relatives. The next factor would be the custodial history of the children. The testimony established that Children's Services had protective supervision with this family since October 2013. The children then were removed from mother's home via a safety plan in January 2014. By the time of the contested hearing in January 2015, they had been removed from their mother for almost a year. This factor, therefore, weighed in favor of granting legal custody. As to the last factor, which is the children's need for a legally secure permanent placement and whether either parent can provide that placement, for the reasons set forth in the argument as to parents' failure to make case plan progress, the parents were unable to provide a legally secure permanent placement.
You are down to 27 seconds.
Thank you.
You timed that very well.
Thank you, Lorna.
Counsel, you have 5 minutes.
Of course, I'll take issue with the argument of Children's Services here, Your Honor. I'm looking at the 2015 January 13 order signed by the judge. Says Lorain County Children's Services hereby tenders to this court a proposed amended case plan regarding the minor children 1TA, 2JA, 3TB, 4JB, and 5KB. And a proposed case plan regarding the minor child 6KA attached here too. That is what's part of the court.
What's the date of that order?
The date is January 13, 2015. It goes on and says anybody that is not in agreement with the case plan to file an objection regarding that, and that's exactly what Father did.
But the March 27, 2015 is the brief that was ordered for 6KA.
Sorry, Your Honor.
The March 27, 2015 apparently is the order for 6KA. Isn't that the child that you're arguing today?
I am arguing that child, but Your Honor, this was the original order, and he did in fact file his objection regarding that decision. Your Honor, I think the agency's argument pretty much highlights what I was arguing earlier. The testimony, for example, about the father meeting the basic needs of the child. The father was working. The evidence was there. I did not want to go into the dispositional evidence, but the truth of the matter is the father testified he was working, and that could have been easily established. All you have to do is local child support enforcement agencies to find out whether father has a support order and whether he's current in that support. Likewise, the home situation. I think what had occurred is that he had someone living with him, and an agent came to the caseworker came to the door, and she said Mr. Burgess was not a resident there, when in reality was, and he cleared that up. And at the hearing, she came in and likewise indicated that she just wasn't truthful with the person that came to the door. Which, Your Honor, again, the agency indicated means to a goal and remedy the conditions which caused the removal. Okay? That the idea is telling the father, you have to support these children. Go out and get a job and then demonstrate to us that you're working, that you're paying your support. Real easy to do. Lorain County Child Support Enforcement Agency, a court order and a wage assignment that demonstrates. I don't see anything about that inside this case plan or this requirement or condition the father must meet. Father needs to have housing. Once again, demonstrate to the, and how are you going to demonstrate that you have housing? You go and you rent an apartment, you buy a home, you demonstrate that you have a deed, you demonstrate that you have a lease. I hear the argument all the time that there are multiple children and the parent is living with relatives in a small place, they're living in an apartment or renting a room. Well, they don't have custody of the children. With mothers, though, the agency will require they go out and apply for Section 8 housing. There are restrictions on applicants. You have to be the custodial parent of the children. They make a condition that somehow you can't meet because there's a condition preceding. The parent has to have custody of the child in order to get an apartment with 3 bedrooms to accommodate 3 children. Father was living in a 1 room because that's all he needed.
But if the case plan says that the anticipated disposition to return the parent to the child to the parent, isn't that what's admissible to Section 8 people to say that, gee, if that's the case plan goal at this point is the child's going to come home? Doesn't that sort of...
I would have to argue, I don't know the exact answer, I would have to argue that I have not seen that in practice. That does not work. The Section 8 housing, for example, there are a huge list of people that are requesting this, and it's allocation of scarce resources, and that's a possibility of getting custody rather than, of course, if there was an order that if you give them an apartment, they will get it. But I've never seen such an order, and that's not, the case plan could say that. I mean, it could be amended, or it actually could be written in order to do that. That's the problem with the case plan here is that it does not. This case plan is a maintenance. It implies a long-term maintenance plan for these children. Even some of the agencies, the children are doing fine. It is a wonderful placement. It would be cruel to remove them. I could agree and say probably is a wonderful placement. I could probably agree and say it would be cruel to remove them. But that's what the law says. The law says you remedy the condition that caused removal of the children, and you reestablish the children with the biological parents. And then the collateral to that must be that Sir, you are the father. Ma'am, you are the mother. You must do this. You must do this because the law requires that you assume responsibility for your children. You demonstrate that you're paying support. You demonstrate that you can house these children. And then these children come back to you by law, not because there's a better placement for
Well,
them.
is one way of demonstrating that by providing support for the children while they're in temporary custody? And that didn't happen.
Well, Your Honor, I guess the case plan, and this one was established in January of 2015, and we are here in April of 2016, and we have no idea what's happened from January of 2015.
But didn't Mr. Burgess, your client, have an order for child support for the 3 older children prior to this case even coming to Children's Services? So wouldn't the Children's Services, wouldn't the child support collection, wouldn't they have diverted his child support to the legal relatives or to the agency who would, wouldn't his child support still have gone toward those children's care?
Oh, absolutely.
Okay, so the legal custodians or the people who had placement of those children during the time the case plan was in effect should have been getting something from him.
Correct.
Had he been paying his child support.
Correct.
And LCCS says that they were not.
Well, the testimony at the hearing, and of course, I believe at one point, he had not been adjudicated the father of the KA, but that he did testify that he was working and that the agency was taking the money from him. That's if I recall the testimony. But that was regarding the other 3 children. And then at some point, he was adjudicated the father. And I assume whether he was current with the support, whether there were arrearages, I don't believe that was established. And I don't recall an agent from Lorain County Children's Services testifying on that. I think it was just a caseworker without, which again, Your Honor, they're not perfect. These hearings are not perfect. There are many areas of the agency. The overall concern is the children and placing them, and I don't doubt that. I don't question the fact that they are in relative placement. That is not the focus of my argument, that the placement of the children were not were harmful to the children. That is not the case. It was relative. The agency did in fact comply with relative placement. But the issues with these case plans is that they are just not tailored the way that they need to be.
And you've reached the end of your time.
Thank you.
Thank you both for your presentations. The court will take the matter under advisement, issue written opinion, send it to both sides, and certainly check the Supreme Court website. Have a good day.